Thank you very much, Madam Speaker. I join this debate in support of this legislation. I've listened very carefully to what members have said opposite, and for yet another time, I continue to be amazed at the arguments that the opposition will put up when they simply don't want to do what is right. I've seen this so many times. You send a bill to a joint select committee because it requires a special majority, and the opposition finds multiple evolving reasons why they will not support it. All of them, in my opinion, can be defined either as nitpicking, irrelevancy, ducking, dodging, hiding. I listened very carefully to the leader of the opposition just now. And I heard the presentation with respect to constitutional rights. I have looked at the law, the bill before the House, and I would say the opposition leader, like the member for Oropouche East, is guilty of misleading her good self, misleading the members on her side, and misleading the general public. That carrying on about constitutional rights, if you have been damaged or defamed, is irrelevant in the context of Clause 8 of the bill, which the opposition leader studiously avoided. The clauses that are being complained about, clauses 18 and 19, provide protection to whistleblowers for what is called a protected disclosure. And to understand what this bill is all about, we first have to understand what is a protected disclosure. And we've had a typical debate and typical contributions from members of the UNC where they avoid the real issues and just dress up their contributions in either emotive language, irrelevancies, or downright inaccuracies and untruths. Let's go into Clause 8 of the bill, Madam Speaker. A disclosure is a protective disclosure if it is made in accordance with Section 7, and we'll come to that in a while, because Section 7 defines improper conduct. It is made in good faith standard. At the time of making the disclosure, the whistleblower reasonably believes, based on the information he has at that time, that the information disclosed and any allegation contained in it are substantially true, and the information disclosed tends to show that his employer, another employee of his employer, or a person acting on his employer's behalf, has engaged or is engaging or is preparing to engage in improper conduct. Most importantly, the disclosure is not made for purposes of personal gain. The leader of the opposition ran away from all of that because the only disclosure that is protected is these types of disclosures. So if you're being bribed to lie about somebody, that fails.
Remember, lie is a word we don't use.
I beg your pardon, Madam Speaker.
Remember, lie is a word we don't use.
No, I'm not talking about any member in the Parliament.
I know. So you are a man of words, you can find a word.
Okay. So if you're being bribed to tell an untruth about somebody, that fails in Clause 8(1)(d), because that disclosure would be made for personal gain. If you've made it in good faith, or if you have not made it in good faith, in other words, you've made it out of malice, that will fail by 8(1)(b). And 8(1)(c) is very interesting, because I remember a matter with the leader of the opposition, when that honourable member said something based on the Honourable Member's belief that the President of the Republic had not consulted with the Leader of the Opposition with respect to a certain appointment. And the Leader of the Opposition condemned the then President for not following the Constitution. It turns out the President did consult with the member for Siparia. She simply didn't read the memo, or she may not have been telling the truth. But when that matter was brought before the Privileges Committee, the defense was, at the time I said it, I reasonably believed that it was so. My staff told me that the President did not consult me, and I believed them. And we were unable to prosecute that privileges matter because in order to be guilty of a breach of privilege, one has to prove that the person did it with malice aforethought, deliberately, dishonestly, and so on. So this definition of what a protected disclosure is falls well within the four corners of the law, well within jurisprudence, well within legal precedent. Because if one looks at clauses 18 and 19, and again, the member for Siparia is guilty of misleading the public. If one looks at 18 and 19, they provide protection for persons who make protected disclosures. So if you tell an untruth on somebody, if you're induced to do that, if you want to damage a competitor, or someone is paid to damage a competitor, or to assassinate the character of a politician or some other person, you don't have the protection. And this is trite law, Madam Speaker. This is trite. That all that we are seeking to do in this Parliament is to protect a whistleblower that acts in good faith, that does not take money to tell an untruth on somebody. It's all here. So every part of the contribution of the Honourable Member for Siparia was wholly irrelevant, absolutely useless as far as persons who are trying to understand what we are all about. It helped no one because it was based on a false premise. It gave the false impression that if this law is passed, if somebody is defamed or somebody suffers some form of damage, they have absolutely no recourse to the courts. That is simply not true. Once it is demonstrated that the disclosure was not done in good faith, or it was done by way of inducement, or the person knew that what they were saying was not true, then that protection is removed. And any kind of action can be taken against the person. That also applies to accomplices. They are not immune. I heard the member for Oropouche East say, where in the Commonwealth will one find legislation like this? I just can't believe the things that they say, Madam Speaker. They just say these things. And I guess they hope that people listening to them will believe them. But even in the document, the Parliament has given to us the Bill Essentials. It gives information on protected disclosures in Jamaica, a Commonwealth country, common law jurisdiction. New Zealand Protected Disclosures Act, Commonwealth country, common law jurisdiction. Canada, public interest disclosure, Commonwealth country, common law jurisdiction. United Kingdom, the home of common law, public interest disclosure. Malaysia, Whistleblower Protection Act, common law jurisdiction, Commonwealth country. So there are numerous examples of disclosure protection in Commonwealth countries, but the member for Oropouche will just get up and say, show me a country which has law like this, and hope people listening to him will believe that poppycock. And now we have to go as to why are we doing this? Why? I was looking at an article, Madam Speaker, published in by the International Bar Association. The title of the article is Are Whistleblowing Laws Working? And when one looks at the abstract, one sees this commentary that in 1978, no country had whistleblowing legislation. 1978, as recently as that. And yet by 2021, 48 countries had it. And once the European Union implements the Whistleblower Directive, and that should have been implemented by the end of 2021, that number will rise to 62 countries in the world have national whistleblower laws. And why are whistleblowers' laws important? They are important, Madam Speaker, to assist law enforcement, to detect and prosecute criminal offenses. I heard the member for Honourable talking about we are all whistleblowers inside of here, because from time to time we come with bits of paper that we have received, that we bust a mark or blow a whistle on somebody who has allegedly committed some wrongdoing. But that's anonymous. And you, Madam Speaker, you are, if you forgive me for drawing you into the debate, as a senior lawyer, you will know that in most cases when one is looking at evidence, there's a requirement for cross-examination of the person giving the evidence. Anonymous disclosure can only take you so far. But you need to be able to interrogate the person making the disclosure. You need to be able to test the truthfulness of what they are saying. You need to be able to question that person to determine whether what in fact they are telling you is accurate. Because an anonymous disclosure can only help you to a certain extent. And I would have thought that was obvious. That was obvious. And any whistleblower must be worried that there would be retaliation. Any whistleblower. They would lose their job. They may be subjected to some form of violence. They may be subjected to some form of persecution. Any whistleblower, this is all common sense. Any whistleblower will want to know that when he reveals information that could expose persons guilty of wrongdoing, that he or she has a form of protection from harassment, from persecution, and other forms of violence, Madam Speaker. That is obvious. And therefore, when I hear members opposite say, we could use this and we could use that, and why you're doing this and why you're doing that, and you don't need legislation, they're running away from the issue. This is not legislation for the PNM. If this legislation is passed by this Parliament with the requisite majority, and I'm told the breach of the Constitution has nothing to do with breaches of privacy and so on. It is to deal with property, because a contract could be voided if a whistleblower comes forward and reveals information which shows that somebody got a contract through fraud or some other corrupt means. The members opposite are running away from is that if we don't enact this legislation, and this is fast becoming the norm in the world, if the members opposite continue like this, Trinidad and Tobago will soon be the only country in the world that does not have whistleblower legislation. We will be a pariah in the Western world. And I'm certain that those financial regulatory bodies like the Financial Action Task Force, the Global Forum, the EU Council of Ministers that the members opposite are always so worried about. How come we're not compliant with the EU? I am sure that as night follows day, that very soon it will be a requirement to have whistleblowing legislation on the books in Trinidad and Tobago. And if we don't, we will find ourselves grey-listed, deemed non-compliant, deemed a jurisdiction that international companies and other persons should avoid. Because the only reason you would not want this whistleblowing legislation is you have something to hide. And you want to protect corruption. That can be the only reason. And for this thing to be in the Parliament, and by the way, how long do I have again, Madam Speaker?
Your time expires at 3:38.
5 minutes. For this thing to have been in the Parliament for so long, for 6 years, it's shameful. And for 6 years, the members opposite have made the same weak and lame excuses about why they won't support this. While every country in the European Union is subject to a mandate agreed by all of them, by all 27 countries, that they will put in place a law for protected disclosure by the end of 2021. We are being left behind, Madam Speaker, and these things have serious adverse consequences. This sort of thing, this sort of resistance on the part of the members opposite can affect our rating on the Corruption Perception Index. So when members come and talk this kind of foolishness in this Parliament, nitpicking about that word and this word, and bringing false law for us, pretending that persons who tell untruths on people that they know to be untruths, that they defame persons would have no recourse. When you do that sort of thing, all you do is you tar all of us with your brush. And the people outside and the people inside Trinidad and Tobago feel that everybody in this public system is corrupt. I reject that. We on this side, we are pushing through. If you don't want to vote, that is your business. Because the population will judge you. The population will decide whether you're filibustering, your old talk, your nitpicking, your irrelevancy, your tedious repetition, your dancing and your dodging. The population will decide whether that is what they want out of a government or not. And I dare say, all right-thinking people in this country will see through the games and the gymnastics of the opposition. And before I close, Madam Speaker, it is astonishing to come into this Parliament and hear people like the member for Oropouche East say that, you know, all this talk about corruption of the governments of which he was a part is old talk. I was just looking at something here. I wondered when the persons associated with a former UNC government were charged in the Piarco airport contract. I just wanted to check and see when. 2004, 18 years ago, Madam Speaker, and I dare say if we had proper whistleblower laws in 2004, this matter, which is still, I understand, at the preliminary inquiry stage, after 18 years, this would have been dispensed with. I remember a particular individual. It shows how things work in Trinidad and Tobago and how they work elsewhere. I remember a particular individual who had been charged in the United States for smuggling guns. Somebody blew the whistle. So the US authorities determined that this individual was smuggling guns. They asked for the individual to be extradited. He fought, but eventually lost the extradition case and was extradited. And I followed that case. He landed in the United States on a Monday. He was arraigned on Tuesday. He went before a judge on Wednesday. And he was convicted on Friday. I saw that. 12 years in jail for that individual. Because they had cogent evidence from a whistleblower. But look at this Piarco case. 18 years and counting. It might be another 28 years before this matter is resolved. So that members opposite could say what they want. They could say what they want. But their administration has been voted out of office on numerous occasions because of the perception of corruption. So stay there and feel that you could pretend and play games. But, Madam Speaker, I simply want to say, Please support this legislation. We need it in Trinidad and Tobago. Thank you.
Member for Cuba South.